Hello, everyone, and welcome to One Civil Law. And for today's story, we've got some exciting news out of the Supreme Court of the United Kingdom. As the United Kingdom comes to a unanimous and perhaps somewhat surprising decision that transgender women are not, in fact, women. This has been somehow a stupid debate, having both in the United States, the UK, Europe, and other stupid countries throughout the world. We're all confined by the stupid. But fortunately, the United Kingdom somehow comes to the right conclusion that biological women are women and biological men are not women. I know. I was surprised too. But this comes up in the specific context of essentially a civil rights law. So the Parliament passed essentially a civil rights law, extending some civil rights to women. We'll see exactly what it was in a second. And then, of course, we had to decide whether or not the biological men who think that there are women somehow fall within the confines of women. And then, of course, not so much, because it's not what the legislature had in mind, because we know how words work, or we're supposed to, or something. So in any event, we're going to go through this decision, follow its reasoning. We turn our attention to the Supreme Court of the United Kingdom. In the judgment of the case of 4 Women Scotland Limited versus the Scottish government, before 5 members of the High Court of the United Kingdom. And we will read their decision. This appeal is concerned with establishing the correct interpretation of the Equality Act of 2010, which seeks to give statutory protections to people who are at risk from suffering from unlawful discrimination. The question raised by this appeal directly affect women and members of the trans community. On the one hand, women have historically suffered from discrimination in our society, and since 1975 have been given statutory protection against discrimination on the ground of sex. I guess they got to it later than the United States did. We got there first. It's nice to beat the United Kingdom on something like that. They beat us on abolishing slavery by about 50 years or so. Maybe it's a little bit less than that, 30 years. But we beat them on recognizing that women have rights too. So that's nice. On the other hand, the trans community is both historically and currently a vulnerable community which Parliament has more recently sought to protect by statutory provision. It is not the role of this court to adjudicate on arguments in the public domain on the meaning of gender or sex, nor is it to define the meaning of the word woman other than what's used in the provisions of some law, which, fair enough. Hypothetically, it could mean something different for some other law. It is a more limited role, which does not involve making policy. They're not supposed to. The principal question which this court addresses on this appeal is the meaning of the words which Parliament has used in the law in legislating to protect women and members of the trans community against discrimination. Our task is to see if those words can bear a coherent and predictable meaning within the law consistent with the Gender Recognition Act. Okay, cool. As explained more fully below, the relevant law seeks to reduce inequality and to protect people whose characteristics with protected characteristics against discrimination. Among the people who the relevant law recognizes as having protected characteristics are women, whose protected characteristics is sex, and transsexual people, they don't call them transgender, nice, whose protected characteristic is gender reassignment. The question before the court is a matter of statutory interpretation, thank God. But before discussing the general approach to statutory interpretation, we set out the structure of this judgment and address terminology. We address terminology, the approach to statutory interpretation, of factual background, and different parts, blah, blah, blah. All right, as to terminology, we're aware of the strength of feeling that's been generated by the disagreements between campaigners seeking to represent the interests of each of these groups, and taxonomy itself can generate controversy. We're content to draw on the terminology used by the Scottish ministers in their written case for purposes of this judgment and have adopted the term. A person who is a biological man, that is, who was born at male sex at birth, but who has protected characteristic of gender reassignment, is described as a trans woman, but not a woman. Trans women are not women. They're something else. They're pretenders. Similarly, a person who is a biological woman, assigned birth at sex female, but has protected characteristic of gender reassignment is described as a trans male. We describe trans women and trans male who have obtained a gender recognition certificate under the relevant law as trans woman with a certificate and trans men with a certificate, respectively, and their gender resulting from the certificate as acquired gender or acquired sex. Oh, the fictions we live with sometimes. We also use the expression biological sex, which is used widely, including the judgments of the Court of Session, to describe the sex of a person at birth, and we use this expression certified sex, certificated sex, to describe sex obtained by acquisition of GRC. So apparently you can change your sex, but you're still not a woman within the meaning of this law. Silly place, man. Okay, question of statutory interpretation. The legislation which this appeal is principally concerned is the EA 2010, and we address the effect of any of the GRA 2004 on the interpretation of the term sex, man, woman, male, and female as used by the EA 2010. The central question on this appeal is whether EA 2010 treats trans women with a GRC as a woman for all purposes within its scope, or whether the act speaks of woman and sex is referring to biological women and sex. So, yeah, you might be a trans woman with a GRC, but are you a woman for all purposes within the meaning of the law? That is the question presided. The general approach to statutory interpretation in the United Kingdom is well established. The House of Lords and this court have set out a basic approach on a number of occasions. Most recently, this court set out the approach in a different case, in which Lord Hodge, DPSC, giving the leading judgment, stated, the courts in conducting statutory interpretation are seeking the meaning of the words in which Parliament used. Hey, I recognize that concept. That's kind of what we're trying to do in the US too. More recently, Lord Nichols of Birkhead stated statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in a particular context. I understand that concept too. Words and passages in a statute derive their meaning from context. A phrase or passage must be read in the context of a section as a whole and the wider context of a relevant group of sections. Other provisions in a statute and the statute as a whole may provide the context. There are words which Parliament has chosen to enact as an expression of purpose of the legislation and therefore the primary source for which meaning is ascertained. Neat. Great. So we're going to understand the word of this text based on the company it keeps. We're going to understand the words of a portion of a statute in the context of the whole so that the entire thing makes sense, because they were trying to speak to one thing, basically. And so we're not going to read a word in isolation. We're going to read it in the overall context. I understand this concept. We do that over here on this side of the pond, too. There's an important constitutional reason for having regard primarily to statutory context. Citizens, with the assistance of their advisors, are intended to be able to understand parliamentary enactments so they can regulate their conduct accordingly. Accordingly, they should be able to rely upon what's read. Hey, that's nice. Yeah, it's like we should be able to understand what they're saying just by reading it. External aids to interpretation therefore must play a secondary role. Explanatory notes prepared under the authority of Parliament may cast light on the meaning of a particular statutory provision. Other sources, such as Law Commission reports, reports of Royal Commission and advisory committees, and government white papers, may disclose the background to a statute and assist the court to identify not only the mischief which it addresses, but also the purpose of the legislation, thereby asserting a purposiveness of interpretation. The context disclosed by such materials is relevant to assist the court to ascertain the meaning of a statute, whether or not there's an ambiguity and uncertainty, and may indeed reveal ambiguity or uncertainty. But none of these external aids displace the meaning conveyed by the words of the statute that, after consideration of the context, are clear and unambiguous and which do not provide absurdity. Great. So they're writing like similar to the way that Justice Gorsuch might write. You know, in somewhat in the vague ambit of it, right? So if the text is clear on its own terms, we can just stop there, right? And the secondary authorities are relevant, if at all, in sort of understanding some other things. But if the text is clear, the text is clear. We can just do this in straight text. Who knew the UK had textualists, or at least hybrid textualists? It's not clear how strict they are about it, but they're in the same vein of being textualist. Who knew? Statutory interpretation involves an objective assessment of the meaning in which the reasonable legislature as a body would be seeking to convey in using the words. Yeah, we're just going to understand them as we do. In a relevant case, the Lord Bingham of Cornhill, these names will never stop being hilarious, incidentally, to the U.S. ear. Lord Bingham of Cornhill. Are we sure that isn't a made-up name? Lord Bingham of Cornhill warned against giving a literal interpretation to a particular statutory interpretation without regard to the context of the provision of statute and purpose. He stated that the court's task within permissible bounds of interpretation is to give effect to purpose. Okay, maybe they're less strict textualists. Maybe they like purpose too. So the controversial provision should be read in context of the statute as a whole, and the statute as a whole should be read in the historical context. So maybe there may be more like originalists instead of strict textualists, because that sounds a little bit more in the originalist wing. So this maybe is a little bit more Scalia or a little bit more Alito than Gorsuch. We're going to look to beyond strict text and look to history and purpose and some other things that help to flavor it. Okay, that's fine too. So maybe they're just originalists. That's all right. Not everyone can be hardcore. The general approach of focusing on the words in which Parliament has used in provision is justified by the principle that those are the words in which Parliament has chosen to express the purpose of legislation and by expertise which drafters of legislation bring to task. I see that the UK Supreme Court is acting under the same fiction of law the US courts operate under. The UK Parliament is a smart Parliament. They're a smart Parliament, and they write things, and they know what they're writing. They're a smart Parliament, and we in the US have a smart Congress. $50 from the Orange Cow. Thank you so much for your very generous super chat. That's very nice. Hey, Kurt, just saw your contempt stream. I agree with you, and like you stick to what you know is true. Please take into consideration the value in getting into with people who aren't looking to learn just for the sake of your mental health. Well, thank you. It's recently as a result of that in controversial streams, I am filtering out non-member super chats to help filter out my natural desire to chase every rabbit hole, because it was just getting too mentally taxing, as I previously explained in a different video. I just need some way to filter it. And so filtering it based on membership seemed like a reasonable approach. Maybe not the best approach, but a reasonable approach. But I did it for my mental health because I was getting to the point where it was a real problem for me. And I think that has been seen in recent videos with me yelling and screaming and all the rest of it. It's not good for me. It's not good for the channel, but I appreciate the super chat. And one of the problems, incidentally, for me is I can't necessarily tell the difference. It's like I can't necessarily tell the difference between the troll and the people who just like are engaging. It's not necessarily clear. So that's a pragmatic problem. But it's like by just filtering the noise, it's better. But thank you. I appreciate it. That's very nice of you. Thank you for your generous super chat. Okay, where were we? But where there's significant doubt about specific meaning of the words used, the court must resolve the indicators of the legislature's purpose outside the provision in question, including the external aids described in paragraph 30, must be given weight. As Lord Sales stated in extrajudicial writing, sometimes the purpose for which legislative intervention was required may be the very prominent focus for legislative activity which falls from it, and thus must frame a particularly strong way in which context. So they're looking to the history of how the thing came about. I understand that concept, right? What was happening that what problem are they trying to solve? Such aids can aid in the explaining of statutory provision, which is open to doubt and can alert themselves to ambiguity, but cannot displace the means conveyed in clear and ambiguous words. So fair enough. If the text is unclear, we're going to go to some other things, but we're going to stick with the text primarily. Lord Nicholas' important constitutional insight in Spath Home, the citizens which the help of their advisors should be able to understand statutes, points to an interpretation that's clear and predictable. As Lord Hope DPSC stated, the best way of ensuring a coherent, stable, and workable outcome is achieved is to adopt an approach to the meaning of statute that's consistent and predictable. This will be achieved if the legislation is construed according to ordinary meaning of words used. Fair. The presumption that a word has the same meaning throughout an act when used more than once in the same statute is consistent with this principle. We have that principle too. See, it's like, this is why one of the reasons why I can read a UK decision or any decision from a Commonwealth country. right? We have enough foundation in common from our shared common law that I can understand a decision from the UK or Canada or Australia or other Commonwealth countries or other countries that derive their law from the UK. So it's like we have a lot of differences, but we have enough in common. And I read this and I'm like, I understand these things. I know exactly what you're talking about. And the reason we have these things in the United States is we learned it from you. So it's like, yes. So it's like, I get it. And then therefore I can understand what you're talking about. It's nice. We have a common language that we can talk about. It's kind of like, I suppose in that way, the difference between English in the United States versus other English speaking countries, right? We may have differences of word choice and differences of expression, but we have enough in common that we can understand what we're talking about most of the time. So, yeah. The way to which this presumption depends upon context which a word or phrase appears as an instrument. The presumption may be stronger when the word is defined in the act. It's generally reasonable to assume the language has been used consistently by the legislature, so the same phrase, when used in different parts in the same statute, will bear the same meaning. Right. When Parliament intended a word to have a different meaning in different sections of the act must be determined from context. Fair enough. All right, so then how did this wonderful dispute arrive? How did this stupid arise in this case? For Women Scotland is a feminist voluntary organization which campaigns to strengthen women's rights and children's rights in Scotland. I'm not sure you understand what women are for Women Scotland, but okay. This case is the second challenge by judicial review in which applicant is raised in relation to statutory guidance which Scottish ministers promulgated in various things. In the first petition for judicial review, the applicant also asserted the statutory definition of woman in the 2018 Act was outside the legislative competence of the Scottish Parliament. What the fuck? Under the Scotland Act, before we turn to the Act and impugn statutory guidance, it may be helpful to outline the basis of the Act. Apparently, Scotland's Parliament does not have the ability to define what a woman is. Interesting. Okay. Interesting. That's an interesting take. Section 29 of the Scotland Act provides that a provision of the Act of the Scottish Parliament is outside competence of the Scottish Parliament if it relates to reserved matters. Section 5 of the Scotland Act specifies the matters which are reserved to the United Kingdom. One of the reserved matters is equal opportunity. Since May 2016, there have been exceptions to reservation of equal opportunity to allow the Scottish Parliament to legislate for positive action measures in relation to persons to be appointed to non-executive posts on boards of certain authorities. Section L2 of Schedule 5, so far as is relevant, states the exceptions as equal opportunity so far as relating to inclusion of persons with protected characteristics in non-executive posts on boards of Scottish authorities with mixed functions or reserve functions. That feels like a very clunky sentence. Equal opportunities in relation to Scottish functions of any Scottish public authority or cross-border public authority other than function that relates to the inclusion of persons in non-executive posts of Scottish public authorities with mixed function or no reserve function. I think someone needs to clean up their writing. Someone in Parliament needs to clean up their writing. The Scottish Parliament passed the 2018 Act to provide for positive action measures to be taken in relation to the appointment of women to non-executive posts on boards of certain public authorities. The 2018 Act sends out gender representation objective for the public board, which is that it has 50% of non-executive members who are women. The attainment of this objective is carefully circumscribed by Section 4, which makes it clear that preference can be given to women in order to further the objective only when there's no best candidate, and only if the appointment of the equally qualified male candidate cannot be justified on the basis of his particular characteristics. Okay. Section 2 of the 2018 Act defines woman as a person who has the protected characteristic of gender reassignment within the meaning of some law, if and only if the person is living as a woman and is proposing to undergo, is undergoing, or has undergone a process for the purpose of becoming female. How do you become female? I don't know either, but that's apparently a thing. In the first judicial review, the applicant challenged the statutory definition of woman in Section 2 of the Act and paragraphs of statutory guidance dated June 2020, which discussed the definition and explained that a trans woman had to meet the three criteria in Section 2: to have the characteristic of gender reassignment, to be a woman, and propose to undergo, be undergoing, or have undergone the process. I don't know what it means to have the characteristic of gender reassignment if you're proposing to undergo the process. What does that even mean? To have the characteristic of gender reassignment. Can you have the characteristic of gender reassignment without actually having undergone the process? Because the third thing seems to think that it is, because in number 3, you can be simply proposing, which means it hasn't happened yet, right? So how do you have the characteristic of gender reassignment if you're only proposing? I don't know. I'm confused. It doesn't make sense. The applicant was successful in appeal before somebody, which held in its judgment that transgender woman is not a protected characteristic under the relevant law, and the definition of woman adopted in the 2018 Act impinges on nature of protected characteristics, which is a reserved matter. By interlocutor, the Second Division declared the definition of woman in Section 2 of the Act was outside legislative competence of the Scottish Parliament. In other words, because the definition of woman in Section 2 of the 2018 Act included trans woman as defined, it went beyond the scope of the exception permitted by the Scotland Act, therefore purported to legislate in a reserved matter, namely equal opportunity, is so outside the competence of the Scottish Parliament. I understand some of that concept. That basically gets into what bodies have what authorities, but I understand some of that. The response of Scottish ministers to the judicial decision was to issue a fresh statutory guidance. This guidance operated on the premise that the decision of the Second Division had nullified the definition of woman. Instead, the Scottish ministers asserted that a person who had been issued with a full GRC that the acquired gender was female, had the sex of woman, so her appointment would count. Again, I object to this in principle, but okay. As explained below, this stance was consistent with advice given by the Equality and Human Rights Commission, which is a non-department public body in Great Britain with responsibility for promoting and enforcing equality and non-discriminatory laws. Yeah, this is a pile of absolute stupid. Let me check something real fast on my own back end, because I've been having a problem and I'm trying to see if I've solved the problem. Yeah, I think I have. Okay. All right. Hopefully. It still looks like it's solved. We'll see. All right. Where were we? Where is the live stream? There you guys are. Okay, great. All right. Let's see. The paragraph of revised guidance with the applicant states challenges. There's no definition of woman set out in the Act with effect in these relevant dates. Therefore, woman in the Act has the meaning under some section of law. In addition, the terms of something else of the Gender Recognition Act, where a full gender recognition certificate has been issued to a person that their acquired gender is female, the person's sex is that of a woman, and where full gender recognition certificate has been issued to that person, their acquired gender is male, that person's sex is of a male. Apparently, you can get a certificate that says you've acquired sex of a woman in the UK. That's interesting. In July 2022, the applicant petitioned for judicial review to challenge the revised statutory guidance issued by the Scottish ministers, which argues it's unlawful because it's based on error of law. The applicant seeks a declarer that the guidance is unlawful in order for its reduction or reduction of those parts which are found to be unlawful. The applicant argues that the guidance is not within the devolved competence of the Scottish Parliament. The petition follows the correspondence between applicant's solicitors and the Scottish Government Legal Directorate. In a letter to the applicant's solicitors, the Directorate referred to guidance entitled Separate and Single Sex Providers, a Guide to Equity Act, Sex and Gender Reassignment Provisions, as updated in April 2022, in light of the decision of the Inner House, which we described above. The letter quoted from various guides, which headed What the Equality Act Says About Protected Characteristics of Sex and Gender, which stated that, under the Equality Act of 2010, sex is understood as a binary, being man or woman. For the purposes of the Act, a person's legal sex is their biological sex as recorded on the birth certificate. A trans person can change their legal sex by obtaining a gender recognition certificate. I wonder how you can change your sex by a gender certificate. I thought, according to some people, sex and gender were different. So how are we changing our sex based on a gender certificate is also a bit beyond me. But, whatever. A trans person who does not have a gender recognized certificate retains the sex recorded on their birth. The letter continued, the guidance confirms that a trans woman with full GRC has changed their legal sex. Again, how is a gender certificate changing anyone's sex? Are gender and sex the same? I'm confused. Has changed their legal sex from biological sex to their acquired sex. Therefore, the trans woman has the protected characteristic under the 2010 Act of their acquired sex. In terms of the 2018 Act, this means that a trans woman with a full GRC must be treated as a woman, which is the position set out in the guidance that your clients disagree with. The stupid is so very, very real. The stupid is incredibly real. The Scottish government revised the position, therefore, is a trans woman with a full GRC is treated as having the acquired sex, and therefore is a woman. They accept the wording of the guidance set forth on paragraph 20 above is unfortunate, insofar as to suggest the inclusion of trans women with a GRC is in addition to biological women included. On their case, therefore, the guidance would mean exactly the same without the third sentence. As explained more fully below, a person who is at least age 18 can apply for the certificate. The relevant law provides that when a full certificate is issued to a person, the person's gender, for all purpose, becomes their acquired gender. So that if the acquired gender is the female gender, that person's sex is that of a woman. How does that follow? Once again, I thought gender and sex were different. Weren't they? That was their proposition. I don't think they're different, but I thought they were different. I thought they thought that sex and gender were different. So how does obtaining a gender certificate change your sex? I thought they were different. Are they the same now? What is the trans community arguing? Are they arguing gender and sex aren't the same? I'm confused. I don't understand. I don't even understand what they're arguing. But that position is subject to provisions made by the Act or any other Act. The central issue on this appeal is whether references in the EA 2010 to a person's sex and to woman and female are to be interpreted in light of Section 9 of the GRA as including persons who have acquired gender through possession of a certificate. I don't know. The focus on this appeal is not on the status of the large majority of trans people who do not possess a full certificate. Their sex in law remains their biological sex. This appeal addresses the position of the small minority of trans people who have the full gender recognition certificate, which somehow also changes their sex. Ben Cooper, KC, who appears for the intervenant Sex Matters, states in paragraph 31 of his written case that based on the most recent census data, the Office of National Statistics estimates there are about 48,000 trans men and 48,000 trans women in England and Wales. And the Scotland census in 2022 found that 19,900 people were trans, compared with a total of 8,464 people who have ever obtained the certificate. He points out that neither possession of the certificate nor the protected characteristic of gender reassignment requires any specific physiological change, which means, again, like I don't have to change my body in any way, right? That's what that means, right? It doesn't require you to actually, so you can obtain a full gender reassignment certificate without necessarily undergoing any physiological change of any description. Presumably that would mean surgery and or hormones. So somehow, some way, apparently I could theoretically obtain a gender reassignment certificate without actually changing anything about myself. As long as I have the intention to at some indefinite period in the future, maybe. Okay. All right, so what did we have in terms of the decision below? So that was their argument position, which their argument position doesn't make any sense. So what did the lower court have to say about the matter? Lady Haldine, is she actually a lady? Do we have to check? Heard the applicant's challenge in the outer house. In a carefully reasoned judgment, she dismissed the petition. She rejected applicant's argument that the inner house's decision in the first judicial review had authoritatively determined that sex was confined to biological sex only. She held that Section 9 of the Act had the effect that the gender recognition certificate changed a person's sex for all purposes, stating that the language of the Act could scarcely be clearer. She rejected applicant's submission that Gender Recognition Act had a narrow purpose which had been largely superseded by subsequent legislation, including legislation establishing the legality of same-sex marriage. She observed that in GRA 2004, listed exceptions to the rule, such as marriage, parenthood, succession, peerage, and trust, and stated the founding principle of Section 9 is a broad one. Well, why would there be any exceptions at all, incidentally? Like, do we believe in this or don't we? Right? The fact that we have to work around it is hilarious. That the acquired gender becomes a person's sex for all purposes subject to any other enactment or statutory exceptions listed. Lady Haldine rejected the submissions that there was a conflict between the Gender Recognition Act and the EA 2010, which she stated was drafted in full awareness of the Act and its ambit, and that the EA implicitly repealed or disapplied Section 9 of the GRA. As a result, sex in the EA 2010 was not confined to biological sex, but includes the acquired sex of those who possess the gender recognition certificate. Thank you, Miss Bucket, for a gift membership. It's appreciated. Lady Haldine therefore concluded the revised guidance of the Scottish ministers of the 2018 Act was lawful. The second division of the Inner House refused applicants' reclaiming motion. The second division, agreeing with Lady Haldine, held the GRA 2004 was a far-reaching enactment which created a mechanism by which a person could change his or her sex in the eye of the law by changing their gender, apparently. So I guess gender and sex are the same. The judgment stated that Section 9 of the GRA read together meant that a person with the GRC acquires the opposite gender for all purposes unless there's a specific exemption, or unless the terms and context of subsequent enactment require a different interpretation. The judgment continued. Should that occur, however, it's expected the inapplicability of Section 9 would be clearly stated, or at the very least, the terms of subsequent legislation are such that they're incompatible with and be rendered meaningless or unworkable by the general principle stated in Section 9. So basically a repeal by implication. She's arguing repeal by implication. She's arguing the later law implicitly repeals the earlier law, which is a disfavored position in U.S. law. We don't really like repeal by implication. We try to avoid it. The second division then examined the term sex and man and woman, and stated such terms could have biological meaning or could bear a wider meaning in accordance with the law. So a trans woman be entitled to protection against discrimination on the basis of sex in her acquired gender. Okay. The terms sex and gender were often used interchangeably. Oh, so they are the same thing. Sex and gender are the same thing. Oh, okay. I thought they were different. I was confused. No, they're actually the same. Oh, thanks for clearing that up. There was a super chat apparently, or a message. Let me see if I can see it. $5 from Jackson Kai, who said the theory is at the point of self-identification you've always been, and the brain of said ID, and yes, change ID, this still follows. I guess. Doesn't make sense to me, but I'm glad it makes some sense to someone. Thank you, Alan Parker, for the gift memberships as always. Thank you, Miss Bucket, for becoming or gifting a gift membership. Thank you, Gene Angry Penguin, and thank you, Internet Commentator, for being a member for 52 months. You are all appreciated. The second division then examined the term sex in sections 7 and 11 and man and woman in section 11 of the EA, and stated such terms could have a biological meaning or could bear a wider meaning in accordance with the GRA, so that a trans woman be entitled to protection against discrimination on the grounds of sex in her acquired gender. The terms sex and gender were often used interchangeably. The provisions of the GRA and EA could be interpreted consistently for the purpose of both statutes if the wider meaning was adopted. There was nothing in the EA that mandated a contrary conclusion. The second division thus considered various provisions of the EA, which applicant argued were unworkable if the wider meaning of the words were adopted. As will be discussed in those provisions below, it's sufficient at this stage to state provisions within the second division discussed relating to armed forces, separate and single-sex spaces, single-sex schools and institutions, communal accommodation, and pregnancy and maternity. Again, the fact that they have to make exceptions in their own law kind of shows they don't really believe what they believe, right? They're really women except for these other purposes, right? Why do you need to have reserved purposes at all? You know? Of those provisions, the second division held only those relating to pregnancy and maternity might require a narrower interpretation of woman as meaning biological woman. The second division also considered and rejected the submission that a trans woman as woman under EA would interfere with the right of freedom of association for lesbians. It concluded that persons with the GRZ possess under Section 11 of the protected characteristic of sex according to the terms of the GRC, as well as their protected gender reassignment. The second division concluded that the guidance on act was lawful because a person with a GRC in the female gender is a woman for the purposes of the act. So I guess lesbians have to accept them as one of their own, even if they still have all their appendages and stuff. At least according to that theory. The applicant now appeals to this court with permission. All right, so now having discussed the lower court, stupid, let's see where we are now. All right, then we have a whole bunch of people who intervened. We'll skip the interveners. All right, so let's discuss the legal background. The Sex Discrimination Act of 1975 came into force on the same day as the Equal Pay Act. The long title of the act describes it as rendering unlawful certain kinds of sex discrimination and discrimination on the grounds of marriage. The structure of the act established a basis for later legislation and several themes which are discussed later in judgment for the first time in this act. The relevant law defined what amounted to discrimination against women. It provided that a person discriminates against a woman in any relevant circumstances if, on the grounds of sex, he treats them less favorably than he treats or would treat a man, or he applies a requirement or condition which he applies or would apply equally to a man, but where the portion of women who can comply with it is considerably smaller than the portion of men who can comply. Section 2 provided that the relevant act would be read as applying equality to treatment of men with such modifications to the wording as necessary. However, the law provided that in applying the act, no account shall be taken of special treatment afforded to women in connection with pregnancy or childbirth. The relevant law provided that the act woman includes a female of any age and man includes a male of any age. Similarly, in the Equal Pay Act, it provides in this act, expressions of man and woman shall be read as applying to persons of whatever age. Section 2 of the SDA dealt with discrimination in employment. The relevant law made unlawful for a person to discriminate against a woman in relation to arrangements he makes for choosing who should be offered the job, the terms he offers, or in refusing a job, which would parallel our law on that fact. Section 6 made it unlawful to discriminate against an employed woman in the way that her access to opportunities for promotion, training, or services. That would also parallel our law. There were several exceptions to the provisions which were designated to establish the boundary. Broadly, the sections exempted discrimination as regards to pay and pension from this prohibition on the basis that differential treatment of this kind would be dealt with in the Equal Pay Act. Fair enough. Certain exceptions were built into the legislation, some of which were repealed long before the act was superseded. For example, according to the law as originally enacted, the prohibition on discrimination did not apply to employment for the purposes of a private household or where the number of people employed was not more than 5. That also parallels our law. I forget the threshold in which it's different, by the way, incidentally, for different provisions of law in which various discrimination provisions apply. So I forget what the threshold is in America. I'm pretty sure it's bigger than 5. I think it's less than 50, though. It's probably somewhere between 5 and 50, but I forget the threshold. Limiting to it where objection might reasonably be taken to limit a person living in the home to physical or social contact to someone with the opposite sex. Section 7 of the relevant law is enacted to provide the exception which is reflected in subsequent legislation, namely discrimination is not unlawful where sex is a genuine occupation. We have that rule too. Bona fide occupational qualification. The UK and us are not so distinct. The exception does not apply to discrimination in terms and conditions in which a woman is employed. Once a woman has been engaged in a job, there can be no genuine occupational reason for giving her less favorable terms and conditions than her male colleagues. The circumstances which define genuine occupational qualification are, kind of what you would think they are. The defenses of genuine occupational qualification can be relied on only where some duties of the job fell within circumstances described but could not be relied on in respect to vacancy where employer already had enough male employees. The relevant law exempted a range of jobs from the ambit of the act in whole or part. For example, as regards prison officers, it was not unlawful to impose a height requirement. Further, the act made some textual amendments to earlier legislation, which assumed all employees in occupations covered by the legislation would be men. For example, the provision in Mine and Quarries Act, which provided no female shall be employed below ground at mine, was modified to apply only to jobs where duties ordinarily require the employee to spend significant proportion of their time below ground. Apparently, women can't be miners. I'm sure that they're deeply disappointed. I'm not sure where the women are fighting for their coal mining rights in the UK, but I didn't know. Apparently, women, you are not allowed to be coal miners. I look forward to seeing your protests for equal opportunity to coal mining jobs. I really do. The language used in the Coal Mine Regulation Act was also modified to reflect the fact that a woman may now be employed. Part of the law also dealt with discrimination in fields other than employment, in particular schools and universities, and provisions of good facilities and services. The law provided it was unlawful to discriminate on the grounds of sex in provision of a wide range of services, including banking, transportation, recreation services of any trade or local authority. Again, there were various exceptions, such as providing accommodation where the provider intended to continue to reside at the premises. I believe this also tracks with our law here. Further, there was exceptions where there's likely to be physical contact between user of the facility and another person. Other person might reasonably object. Well, U.S. law would just treat that as a bona fide occupational qualification at that point, to be honest. The relevant law conferred further exceptions. We don't have to read the exceptions. The relevant law was amended in important respects before repealing it by the other law. What we draw from this conclusion are the following points. First, there can be no doubt the Parliament intended the words man and woman in the SDA would refer to biological sex. The trans community, of course, existed at the time, but recognition and protection did not. Yep. Stop making you laugh, your head hurts. If I can inject some humor into this, I'm doing something right with my time. If I can inject a funny every once in a while, we're doing okay. Secondly, the legislation recognized and accommodated the reasonable expectation of people in situations where physical conduct with people or where people would be undressing together or living in the same premises or using sanitary facilities together, considerations of privacy and decency require separate facilities. Third, a range of other exceptions were considered necessary and reasonable, particularly in relation to sport, where typical masculine physique would be given an unfair advantage, notwithstanding what the governor of Maine wants to say on this issue. And I hope she gets sued into oblivion. Test, it works. Thank you, New York Renal MD. Yeah, sorry about that. I don't know what happened. I apologize to you earlier, but I'm glad that you were able to super chat and participate now. I'm not quite sure what happened there, but glad we were able to resolve that problem. YouTube being weird, I guess. Discrimination on the basis of transgender. The common law of England and Wales did not recognize the possibility of a person being different gender from their gender at birth. In a well-known case, the High Court declared that marriage was null and void, where both parties were biological males, but one had undergone gender reassignment. In one relevant law state over a very large area, the law is indifferent to sex. In other areas, such as insurance and pension schemes, there was nothing to prevent the parties to a contract from agreeing the person concerned should be treated as a man or a woman, as the case might be. But marriage was a relationship between a man and woman, and in the context of marriage, even for not other purposes, the person was still a biological male. That conclusion that the person could not change their sex was applied in the criminal law. In a relevant case, the European Court of Justice considered the scope of the Equal Treatment Directive. That is counsel directive in context of alleged discrimination connected to gender reassignment. The applicant, a biological male, was dismissed by Cornwall County Council after telling her employer she intended to undergo gender reassignment surgery. She complained of unlawful discrimination on the basis of sex. The judge recorded that the Industrial Tribunal found there was no remedy under the Sex Discrimination Act of 1975 The applicable United Kingdom statute, since English law took cognizance only of situations, is the European Court of Justice interpreting a UK law? That seems weird, right? I mean, no wonder you guys had Brexit, man. All right? Damn. The European Court of Justice is interpreting UK law? Shit. Anyways, the court at paragraph 18 held the directive was simply an expression in the relevant field of a principle of equality, which is one of the fundamental principles of community law. The right not to be discriminated against on the basis of sex was, the court said, a fundamental human right. Accordingly, the directive also applied to discrimination arising from gender reassignment. The decision led to the adoption of the sex discrimination regulations. The regulations amended the law in relevant ways. You guys amend your laws by regulation? Oh, okay. First, the regulation inserted section 2A, which defined discrimination as including treating a person B less favorably on the ground that B intends to undergo, has undergone, or will undergo the surgery for the purpose of any provision in the relevant law. They're ruling on their own directive? Okay, then maybe I misunderstood what they were writing. Fair enough. I apologize. Section 3 of the SDA gender was inserted. By the way, can I just have a random moment just to talk about something that bothered me a little bit? Like in the last stream, I was talking about this issue about whether or not terrorists can be state sponsored or not. And someone made what I thought was a reasonable point. And then I did what I thought would be the reasonable thing to do. I considered the point. I'm like, yes, that seems like that's a thing. This somewhat undermines my position. I might have to give this some further consideration. And then I'm like, okay, assuming it's true, how does that apply to the current situation on the ground? How does that apply to the El Salvadoran situation? Does that principle apply here? And then I had some thoughts relating to that. And one guy in the YouTube comments in particular was basically said that I was scrambling and trying to, backpedal my position. I'm like, I don't think that's fair. I don't think I was scrambling or backpedaling. I don't think that's fair. What happened, at least from my own point of view, is that someone made an argument. I thought the argument was good. The argument undermined my position. And I'm like, okay, now I have to reconsider my position. How's that backpedaling? As so much as saying, oh, geez, you made a point and I have to figure out that now. It's like, what do you want me to do exactly? It's like, what do you want from me? And then I'm like, okay, assuming it's true, does it apply in this situation? And then I tried to apply it to the situation and at least partially distinguished. But I don't know what some people want me to do. It's they don't want me to consider new information or something. I just I don't understand. It's sometimes people make arguments and I'm like, oh, that's a good argument. I have to reconsider my position. I'm confused. I don't understand. Yeah, it's like, yeah. So it's I don't understand. It's what do you want me to do? You just want me to double down no matter what anyone says, just stridently defy and just double down and just stick to the same position no matter what? That doesn't seem like a good thing to do. That doesn't seem intellectually honest. Anyways, pressing on. The 1999 regulations did not insert a freestanding prohibition on discrimination separate from Section 6. Rather, prohibition on discriminating against a woman now prohibited direct discrimination as defined by Section 2, namely on the grounds of gender reassignment, but only in the employment field. It was therefore unlawful under the relevant law to discriminate against a woman in the ways caught by Section 6 on the ground she intended to undergo or was undergoing or had undergone treatment. In light of this section, this also made unlawful under Section 6 to discriminate against a man if he treated him less favorably on that ground. However, Section 6 was prevented to overlap with the Equality Act, which this applied to discrimination in respect to pay and pensions. I have to be honest, I don't like the way the UK Supreme Court writes as much as I like the way the US Supreme Court writes. I find the way that you write, I find the way that the UK Supreme Court writes to be a little clunky. To my mind. Regulations 4 of 1999 regulations insert Section 7, which provide for an exception to prohibition and discrimination. Where discrimination fell within Section 2, but where being a man or being a woman was a qualification for the job and the treatment was reasonable and relevant to the views. Further, Section B was inserted into SDA to provide an additional exception to the unlawfulness of discrimination under certain elements where there's a supplementary genuine occupational qualification for the job. A supplemental qualification was defined in the section as arising only in the circumstance under Section 2. Yeah, I actually, yeah, it's why I make a good federal judge, right? I'd like to think so. It's like if someone makes a good argument, I'm like, oh wait, no. I'm like, no, wait, I have to rethink something. Right? It's like I made a mistake. Judges make mistakes too. We're all human. And we don't always think about everything. Sometimes we miss something. And if someone makes a good argument, you're like, wait a second, no. I have to rethink my position. And maybe I'll still get to the same place in the end. Maybe I'll eventually get there and I'll be like, in the end, I still wind up at the same place. But I at least have to think about it. It's like, come on. Some of these exceptions were limited to where a person was undergoing or had undergone gender reassignment. It did not accept discrimination in a person intended to undergo gender reassignment. Others applied only where the person intended to undergo or was undergoing gender reassignment, but not where the person undergone gender reassignment. Similar exceptions to the relevant law were provided. Okay, do I really have to keep going through? I think I'm going to skip ahead and get to the meat of this thing. Jackson Kai says EU law supersedes local law for supposed enforcement of universal trade law. Rejecting it can allow them to throw you out of the union. Well, the UK threw itself out of the union, so got that covered. But yeah, the fact that we're trying to do this by trade, though, is an interesting thing, right? It's like we want to have trade facilitated. In order to do that, we need to talk about human rights. It's a weird way of going about business. I'm going to skip some of the background and sort of get to the heat of the thing. Okay, I'm going to skip what. Yeah, well, I guess. All right, what do I need to do to get a gender certificate? I'll read that. All right, so what do I need to do? All right, the panel must grant the applicant if the applicant satisfies these criteria. Apparently, this is what I need to do to get a gender recognition certificate. Has or had gender dysphoria. Well, that's just basically my self-description of myself, so I'm there. Has lived in the acquired gender throughout a period of 2 years, ending on the date which the application is made. Sure. Intends to continue to live in the acquired gender until death, and complies with evidential requirements. Apparently, that also requires 2 medical reports, and the report must include diagnosis of gender dysphoria. If I've undergone or is undergoing or plans to undergo, one of the reports must include details of the treatment. The applicant must also provide a statutory declaration that they've lived with the gender treatment for 2 years. So basically, it's whatever I say it is. That's fine. That's fine. I can do that. All right. So yeah, I can get my gender research certification from the EU or UK. All right. We're going to skip the case law relating to the certificates because I don't care. Living in an acquired gender. The requirements have not been interpreted to require, for example, biological men to prove they've modified or intend to modify their physical appearance so as to pass for a woman. Outstanding. I don't have to change anything about me. I can just be a woman. It's fantastic. Blah, blah, blah. Blah, blah, blah. Case law on the effect of the issue. I'm going to skip out the case law for the moment and go through the history of precedent and some more case law and some more precedent. The Equality Act is an important piece of legislation with wide scope. It regulates relationships, intends to reform and harmonize equality law and restate on greater part. It's arranged over 16 parts and 28 schedules. Holy shit. So what does it relate to? Direct discrimination, combined discrimination because of 2 relevant protected characteristics, discrimination, disability, gender reassignment discrimination, pregnancy and maternity discrimination, pregnancy and maternity work, and indirect discrimination. Uh-huh. All right, so we can skip that. The relevant protection afforded by the EA to the individual and groups. At the individual level, it does so primarily by means of a general prohibition against less favorable treatment in the form of overt or direct discrimination because of one or a combination of protected characteristics, or by means of more specific direct discrimination, which operates similarly in relation to particular characteristics. Okay, I mean, I understand all that. I understand that. I don't need to read that section. Blah, 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 blah. Protection from discrimination afforded by a group basis. I understand that. We don't have to read that. Blah, blah, blah. The importance and clarity and consistency with legal rights and duties imposed. Imposes legal rights to individuals who are vulnerable and protects against unlawful discrimination and seeks to advance equal treatment. Yeah. An obvious example of a conflict emerges in employment cases concerning protected characteristic of religion on belief on the one hand and sexual orientation on the other. See, for example, a case which concerned disciplinary proceedings taken against a designated civil partnership registrar who refused to conduct same-sex civil partnership ceremonies in accordance with the law on the grounds the unions were contrary to their belief. I don't know how that panned out in the UK law. Poses duties, relevant group characteristics. Central question. Does the EU make provision within the meaning of the law to displace application of 9.1? To recap, Section 9 of the GRA, read in Section 2 and 3, has the effect that the gender of a person with GRC becomes the acquired gender for all purposes, so that if the acquired gender is male gender, the person's sex, and again, why sex and gender are the same thing, is beyond me, the person's sex becomes that of a man, and if the female gender, the person's sex becomes that of a woman, unless there's a specific exception in the law itself, or unless the terms and context of the enactment, including subsequent enactment, demonstrates their provision made by the enactment. In other words, Section 9 applies unless Section 3 applies. Section 3 will obviously apply where the enactment says so, but express application of Section 1 is not necessary. Section 3 will also apply where terms, context, and purpose of the enactment shows it does, because of clear incompatibility with Section 1. There is no doubt that the ERA of 2010 was enacted with knowledge of existence of 2004, its consequences, and case law. Indeed, the relevant law contains an exception for gender reassignment discrimination in the context of solemnization of marriage. There's no provision in the E that expressly affects the effect of Section 9.1 has on the definition of sex or the term woman or man. Term biological sex and certified sex do not appear anywhere in the Act. However, the mere fact the word biological is absent from definition of sex is not itself indicative of Parliament's intention that certified sex meaning is intended. The same is true in the absence of the word certification in the definition of sex. If the EA can only be read coherently to mean biological sex, the same result must follow. The question must be answered is where the provisions in the EA 2010 that indicate that biological sex is plainly intended, or that certificated sex renders meanings incoherent or giving rise to absurdity. Interpretation that proves unworkable, impractical, anomalous, or illogical is unlikely. So one of the things we can do is, if we said it was true, would everything break? Right? If we said it was true, would everything break? And if it does, that's probably not what they meant. What is necessary, therefore, is a close analysis to identify whether there's indicators within it that demonstrate that Section 9.3 applies and displaces the rule of 9.1. We start by considering the core provisions in the law that depend on or relate to sex. To consider whether, as a meaning of ordinary language, these provisions can only be properly interpreted as biological sex, or where they're also interpreted extending to include persons living an opposite acquired gender. We will then consider the practicality and workability of these duties imposed. Before the enactment of the GRA in 2004, there was no doubt that references to sex, man and woman, were references to biological sex, because we weren't idiots. On the enactment of the 2004 law, we've explained above, limited changes were made, but this is not done by amending the definition of sex and introducing a completely new concept of sex. Rather, sex remained biological sex, as we've explained. There's no reason to suppose that Parliament intended by the 2010 Act to introduce a change of substance from the 1975 Act by introducing a modification of the meaning of sex in accordance with 9.1. The parties did not draw our attention to anything in the documents would led up to the enactment, which identified a perceived mischief that needed change in the substance of the law. But even if we're wrong about that, and we acknowledge it's difficult to understand the purpose of some of the amendments, the EA both consolidated and reformed anti-discrimination law. As a self-contained reform statute, it should be interpreted, if reasonably possible, without recourse to the predecessor. The relevant law provisions were repealed and many of the exemptions were fundamentally reframed. Thus, whatever the position remained in, the focus of our law is necessarily the 2010 law, which, kind of sort of also would sort of be our thing too, particularly if you're more a textualist. But referring to previous versions of the law to understand what they're referring to is very common in US law too. So specifically, like if they change something, like and you see this in Supreme Court decisions, like there was a provision in a prior law, like that was dropped, and someone tries to argue that same provision is still true. And like nothing in the new law, like explicitly says it wasn't true anymore. But the Supreme Court basically says, well, Congress must have meant something by dropping the language, right? I mean, it used to be there and now it's not there. It probably meant something. So it would be not a good idea to interpret it as still being there because they removed it for a reason. But, ultimately the text of the thing controls at the end of the day. Fair enough. We've said our approach to statutory construction is above. Our task is to ascertain the meaning of the terms sex, woman, and man used in the relevant law rather than their particular context in light of the wider context and purpose. Two specific characteristics at the heart of this appeal are sex and gender reassignment. We've read those before. In other words, what makes unlawful is sex discrimination against women and men, and the provision ensures that boys and girls are protected. The definition of sex in 2010 makes it clear the concept of sex is binary. A person is either woman or man. So the UK agrees with us. There are only two categories, notwithstanding the people with the strange chromosomes. There are only men and women. So as to which you are, people with the strange chromosomes, I'm not sure, but you're one of them. We'll figure it out maybe on an as-applied basis, but you're one of the two. Although the word biological does not appear in this definition, the ordinary meaning of those plain and unambiguous words corresponds with biological characteristic that make an individual man or woman. Man and woman on the face of definition only differentiate as a group by biology shared within the group. A certificate, I guess this is the meat of the thing, a certificated sex interpretation would cut across the definition, a protected characteristic of sex in an incoherent way. It is incoherent, I agree. Reference to, gender dysphoria is a term that describes a sense of unease a person may have because of a mismatch of sex and their gender. Yeah, what does that mean? A sense of unease? Do I have any unease about my own sex or gender? I mean, probably. It's like, a sense of unease. And what does that mean? And it's like, what does it mean? It means kind of anything you want to mean, I think, in the end. It's where the problem. It's one of the problems, among many problems. I could be manlier. I mean, we probably all could. Losing some weight would be good. That'd be a good start. We can clearly identify no reason which the legislature should have intended sex-based rights and protections that should be complex, heterogeneous groupings rather than a distinct group of biological men or women. Maybe I should take up fighting sports. Is it too late? I do think they do have a an elder group for MMA. I think they have a over the hill group for MMA. Maybe it's not too late. Maybe I should become a over the hill MMA fighter. Maybe I could appear in competitions. It'd be fun. Get my ass handed to me. I need to lose more weight first, then we'll talk. Moreover, it makes no sense for conduct under the relevant law in relation to sex-based rights and protections to be regulated on a day-to-day basis. Some of the practical consequences of a certificated sex definition are described in the case by Sex Matters. They state the uncertainty and ambiguity about circumstances which led to treat biological women and girls as a distinct group whose interests need to be considered and protected have the effect on many organizations now feel inhibited from doing so. The definitions in the law are similar to those in the SDA. Mr. O'Neill relied on contrast between definitions in section which states that in this act, woman means female of any age, and the previous provisions state woman includes a female of any age. We do not consider this change to be significant. In both cases, the meaning is simple, to mean clear that boys and girls are also included within the definition of man and woman. We do not see the words includes and means as sufficiently distinctive to lead to any inclusion. Yeah, what is the difference between includes and means? I guess means is narrower. I guess means is slightly narrower than includes, but not enough for us to get anywhere. As significant, however, there's only one definition of sex. The concept of sex is of foundational importance. The words sex and woman appear across different parts of the act and in many sections. It'd be surprising if the words sex and woman were intended to have different meanings in different sections or parts of the law, especially given the definition of man and woman in the law. Indeed, it would offend against the principle of legal certainty and the need for meaning which is consistent and predictable, especially in the context of the act, which the purposes have identified and which such practical everyday consequences for so many individuals in society. I can only hope that one day when this question comes to the US Supreme Court, in whatever context this is going to be, it will be 9-0. That's probably hoping for a lot. The most likely way for the Supreme Court to confront this question is going to be in the context of Title IX. That's going to be the most likely way for them to confront this issue. Because Title IX prohibits discrimination on the basis of sex. And then they're going to have to decide whether or not what transgender means and relevant to that. Will it be 9-0? I have my doubts. But one can hope. The general rules as we state is the words or terms more than once in the same legislation are taken to have the same meaning which they appear, and the general purpose of interpretation provision is to fix the meaning of the term throughout the legislation. The presumption can be rebutted when the context requires, even where a saving for context does not apply in the definition. But this is likely to be rare, and given the valuable meaning to defined term is generally only done where it's clear that there's a genuine drafting error resulting in differential usage of the word or term in the text or legislation. Is there a case getting close to the Supreme Court? I don't know the answer to that question. Probably is the answer to your question. Yeah, I mean, like there are cases on Title IX that are at the Court of Appeals like all the time. So could the Supreme Court like yank one of those cases out and decide the question? Yeah, pretty much at any time they pretty much could. So there are Title IX questions all over the place. So whether or not any of those cases is a particularly good vehicle, I couldn't say. But if the Supreme Court really wants to, yeah, I mean there are cases that would enable them to take up this issue. But of course, the most likely way for them to do it is probably relating to some of the stuff happening right now with respect to the mayor or the governor of Maine being denied funding. Like that's the most likely way for it to percolate. So in terms of time frame on that, it depends on a whole host of factors. But 5 years is a reasonable expectation for the Supreme Court to get involved. But again, there are cases that they could take up, and it could go faster than that. But yeah, sometime within the next 5 years, I think is a reasonable expectation. The Supreme Court is probably going to take up this question at some point in that time frame, if I had to guess, which I do. As we shall demonstrate, a strong indicator that the words sex, man, and woman have their biological meaning is provided in the relevant law and the related provisions. The provisions afford those provisions, the protection afforded by those provisions predicated on the fact of pregnancy or the fact of having given birth to a child and taking leave of consequence. Since it's a matter of biology, only biological women can become pregnant. Don't tell that to the trans people, I tell you what. The protection is necessarily restricted to biological women. The repeated reference in this section to women who have become pregnant or breastfeeding makes only sense if sex has biological meaning. Again, don't tell that to some of the trans people, I swear. This plain, unambiguous words can only be interpreted coherently as references to sex, female, and males. Put another way, if acquisition of a certificate apply those words to a biological woman living as a trans man or male, they nonetheless be excluded from the protection when pregnant, notwithstanding a continued capacity to become pregnant, and duty bearers would not be able to claim relevant exceptions. That's true too. So if a trans man became pregnant, they wouldn't be protected under that interpretation. So like that's true as well. No problem, Average Dev. I'm always happy to answer questions. Yeah, I'm always happy to answer good faith questions at least. Section 613 in the Constitution of Discrimination provides that the protected characteristics is 6. Less favorable treatment of a woman includes less favorable treatment of her because she's breastfeeding. This obviously applies only to women. As a matter of ordinary language, it necessarily excludes all male. Don't tell that to some of the trans people, I swear. Section 17 makes a provision for circumstances where it discriminates against a woman if it treats her because of pregnancy. Again, all biological women, but only biological women are protected. All biological men are excluded because they can't get pregnant. There are other provisions of the law that have similar effect. For example, in a different section provides for further protections for maternity-related pay and for operation of maternity equality rule and tertiation of occupational pension does not treat time on which a woman is on maternity leave as it treats time when she's not. These provisions expressly apply to women only. A woman is employed or holds personal or public office. Section 9 is also relevant. It sets out a series of exemptions from general prohibitions which render it unlawful for employers to treat employers with certain relevant protected characteristics. Paragraph 17 is an exception relating to provisions of non-contractual payments to women on maternity leave. A person does not contravene this section so far as relating to paternity and maternity by depriving a woman who's on maternity leave any benefits or terms of pay. Yeah, so I think we sort of got the point, right? We got the point. And it's basically, if you interpret the law and you look at these provisions, they obviously only had biological sex in mind. So I think that sort of will sum up our reading today. And let's see if there's anything else here. No variable definition of woman. In reaching a conclusion, the prior body recognized there might be other provisions where it might be necessary to adopt what they described as contextual interpretation of sex. However, they regard it as impractical. We respectfully disagree. By nature, a variable definition is neither clear, consistent, nor predictable. It is the opposite, in fact. Apparently, the UK Supreme Court does not believe in the Oxford comma, which is a shame because it's called the Oxford comma. Get with it, Supreme Court of UK. It's also contradicted by a single definition of sex that fits within the meaning. Citizens with assistance of their advisor tend to be able to understand the enactments. Blah, blah, blah. We do not regard either point as justifying a variable definition for sex. The definition of sex is foundational. The bare assertion that the definition is not impermissible as a matter of statutory construction falls short of applying any compelling basis for concluding it's variable. It's simply not plausible to think the definition of sex, as used in pregnancy and maternity-related provisions, is the result of a genuine drafting error. There are no circumstances in which a biological male can become pregnant, and no man, therefore, ever can be an appropriate comparator in a pregnancy discrimination case. Fair? As we explained, the pregnancy discrimination provisions are deliberately framed on the basis of unfavorable rather than less favorable treatment and tied to biological males. If the Scottish minister were right, this would suggest the legislative intention to provide protection only for pregnancy of women who do not have the GRC and to exclude persons living in the male gender who do have a GRC who may become pregnant. It's difficult to see a reason for such an approach. So the Scottish minister is out of their mind too. The intro bang is the best punctuation. Respect. Women didn't start this fight. I feel like women kind of did start this fight, to be honest. I feel like it was I mean, maybe that's a biased perspective, but I don't think it was the men in the US or UK for that matter. I could be wrong, but I don't think it was the men who were in the first instance screaming for trans people to be recognized. I think it was the women who started this fight. I think it was the women who started in the name of the equality and then wound up undermining themselves. But I could be wrong, but that's my impression. It's women generally who are like more inclusive and want to be fairer, and it's women who are generally like like your feelings are important and stuff like that. So yeah, I think the women might have started this fight. And blah 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 blah. Okay, that's going to bring us to the end of this case because I think we sort of got the gist, and we can stop reading. I don't want to read every word, and we got the gist. So, yeah, fair enough. It's just if you interpret it the way that the people who say that we should allow trans women to count, if you interpret that way, it leads to a whole bunch of contradictions. And we don't want to interpret sex in one provision differently from another provision in the same thing, because we want to interpret the word to mean the same thing throughout, because that's normally how we roll. And so, yeah, all that stuff. So, yeah, that basically is true. And now people can kvetch about it. Yeah. I think women are more susceptible to luxury beliefs. Maybe. Women are also much more used to just like lying. Oh, that was a bad way of phrasing it. I'm sorry. I need to rephrase that drastically. I'm so sorry. People, women are more willing to tell untruths in social situations. They're more likely to say like every woman is beautiful, every woman is a 10, every woman is beautiful in their own way. It's like you don't really believe that. You know you don't really believe it, but women will say it. They'll say it like every woman's a 10, every woman's equally beautiful. Every woman is great and beautiful and wonderful, and every woman's fantastic. It's like you don't believe that. I know you don't believe that, but you'll say it for reasons that are beyond me, but you'll say it, you know? But yeah, it's like men don't do that kind of thing. Men don't say all men are equally valuable and equally strong and equally handsome. Men don't do that. You know? So they're more likely to tell untruths to smooth a social situation. You know, and promote everyone belonging and so forth and so on. So toxic empathy, something like that, yeah. Something like that. You empathize so far, you wind up completely undermining yourself, you know? I remember that like scene from was it Walking Dead, I'm pretty sure. I think it was Walking Dead, like one of the early episodes. So where there was this guy who was like a prepper, and so he had a lot of resources. He had like a lot of food and a lot of stuff. And as memory serves, they were like stuck on the highway, right? Because everyone was trying to flee the disaster, and like so they were stuck on the highway. And another couple came up to them. A woman came up to him. It might have been a woman and a man. Came up to them and basically said, "Do you have any food that you can give us?" And the woman who was part of that thing said, "Yes, we do." And the man said, "No, we don't have any food for you." And so sent her away. And the woman who was with him, like, basically chastised him and said, "We had plenty of food. It was like we had plenty of food. We could have given her food." And he basically said, "Well, we can't for operational security." And the man's right, because what happens if you give her food? Right? What happens if people realize that you have food and everyone needs food? What happens if people realize you have food? What happens then? Right? What happens is people come and take your food. They kill you. They take your food. And like it's like if we give her food, we violate our operational security. So in the name of compassion, because this woman is starving, has a child, right? She's starving, has a child, she needs something for her food. But in the name of compassion, you're going to give her food. And then people see she has food and they're going to wonder where she got the food, and then suddenly we're fucked because of your compassion. Right? So it's like, yeah, it's that kind of thing. You know? So all that kind of stuff. Yeah, if you feed it, it'll never go away too. And they'll be back for more food because they still don't have food, right? The problem is going to just reappear. They're going to be back for more food later. And then they're going to be upset you didn't give them food. And I mean, it's a total nightmare. It's a total nightmare. Every bit of food he gives away is less food for him and his family in the end times, right? It's like, I need food for I need as much food as I can possibly have, because eventually it will run out and then we won't have food. I need food as long as I can have it. So it's like, I mean, he was completely right, but they played him like the jerk. They played him like the jerk on the show, but he was right. So it's like, what can you do? All right, guys. Well, I think I'm going to sign off for now. And if there's anything else you guys want me to respond to, let me know. And we can have more streams with more things. and have more conversations. It'll be fun. But the nice that the UK, yeah, it's nice that the UK came to the most reasonable decision. Yeah. Yeah, there might be an argument to use your resources to create an enclave. Yeah, maybe that's a fair point. But if you want to do that, you want to do it in a much more controlled situation. Right? That situation was not controlled. As memory serves, they were on the middle of a packed highway. They were surrounded by lots of different cars, all of whom are in a moment of desperation. So if there's a case to be made for giving away some of your food in order to secure alliances, maybe. But you'd want to do that in a much more controlled fashion. It was not the time and place, assuming that it's prudent at all. But yes. Jackson Kai for $2 says, thanks for reading. It was very interesting. You're welcome. And then you kind of saw that also in The Walking Dead later with the, what was his name? The governor who had created a little society for him and his people in a much more controlled circumstance. So, there was that. All right, guys, I'm going to sign off for now. Thanks for joining me. Let me know if there's anything else you want to consider. I could use a fun one. Maybe we'll do a body cam thing later today or something. We'll just do something fun and silly and watch a person being stupid and getting maybe tased or something. That could be fun. Maybe we'll do something like that. But until later, I've been Uncivil Law. I hope all's well. Cheers for now, my friends, and goodbye.